Hey class, good morning. Hey, this is going to be the integrity video for chapters 7 and 8, so it's going to be last week and this week's combined. And the reason I waited to put these two together into kind of one presentation is because both of these chapters are, chapter 7 is really short in your text, and chapter 8 kind of ties in with chapter 7. And in many textbooks, all of this is combined into one chapter anyway, so I'm just going to kind of combine it because it all has a common thread, which is the use of hearsay. So I'm going to be skipping over some of the slides here, and I'm going to be talking about some of the main points. Hearsay is just not as complicated as it may look by reading all the information in the text. So you can see what the learning objectives are here. It says define hearsay. We're going to be talking about that. It says list the questions that should be asked to determine if a statement is hearsay. State why hearsay raises questions of reliability. Define an assertive statement. Explain why the statement "he said he would kill me" might not be hearsay. State the co-conspirator rule. Identify when a prior statement by a witness is not hearsay. So that's kind of what's contained in this chapter. And I'm not going to be talking about every one of those things because, you know, you're all smart enough people that you can be reading your chapters, and then you should be using me to help ask questions for the things that you don't understand, as well as I should be. My job is to help clear up some of those things that are typically the muddy water in regard to these ideas. And you know, basically this course is an introductory law course, especially as it has to do with how evidence is admitted at trial. So I'm going to start out with just this idea that in our criminal justice system, as opposed to our civil justice system, there are completely different rules on the use of hearsay. Now I'm going to define hearsay first. Your textbook says hearsay is secondhand testimony, reports by one person about what another person said. So basically hearsay is any information that somebody would be on the stand giving that they did not have actual personal knowledge of. For example, if I was on the stand and I was testifying, I am supposed to only testify to information that I personally know, that I witnessed, that I saw. I am not supposed to be able to get up on the stand and testify to information in a criminal trial. Let's say that I get on the stand and I say, well, Joe Bob told me that he killed Terry John. I'm not supposed to be able to say that on the stand. If I saw Joe Bob kill Terry John, I can testify to that, but I can't testify to the fact that Joe Bob told me that he did, because I don't have personal knowledge of that. Or if somebody else tells me that Joe Bob did something and Joe Bob is the one on trial, I cannot testify to that. I can only testify to that information that I have personal knowledge of. Now there are some exceptions, and we'll talk about those here in just a few minutes. But as a general rule, that's what hearsay is, and the fact that it is not admissible in a criminal trial because the burden of proof is so high in a criminal trial. You know, you have to prove guilt beyond a reasonable doubt. Now, here's the monkey wrench in the works, though. In a civil trial in the United States, hearsay is admissible because the burden of proof is much lower. You only have to tip the scales toward one side or the other in a civil case. That is a preponderance of the evidence. So therefore, you could get on the stand and you could say what somebody else told you in a civil case, in a civil trial. And part of that reasoning is also the fact that we don't punish people if you lose a civil case. You just have to pay money to somebody. That's the remedy in a civil case, is money damages, not about taking someone's rights away and punishing them. So another issue with hearsay is that if I get on the stand and I testify to what somebody else told me, we don't have a way to cross-examine that because that person's not here. So that kind of also violates the constitutional rights of the defendant, where you have the right to cross-examine witnesses. So there are several reasons why hearsay is not admissible in a criminal trial. All right. So testimony is generally seen as presenting 4 risks relating to its truthfulness. Now this is the evidence that a witness would give on the stand in a criminal trial. They have to look at the accuracy of their perception, their memory, the meaning of the testimony, and their sincerity. It's pretty interesting when you look at some criminal cases, because some of the witnesses that testify just don't come off as credible at all. I mean, they may be getting up there and they may be testifying to information, but their perception could be off, their memory could be flawed, the meaning of their testimony could be different to you, or it could be different to them than what it is to you, and they just may not be sincere. They may just simply be trying to get somebody in trouble. And so we have to be very careful about how we allow witnesses to testify, and we cannot allow them to testify to things that they do not have personal knowledge of. And they will try it. They will try to testify to those things that somebody else has told them that they now believe as the truth. And that's where, a good attorney on the other side, whether that be a defense witness or a prosecution witness, or whatever the other side's attorney is, has to be sharp enough to recognize that fact and then try to catch that witness in an inconsistency or a lie, which would then in turn destroy the credibility of that witness before the jury. Hopefully that makes sense to you. Hearsay in most federal and state criminal proceedings is inadmissible under the relevant hearsay rule. Even if something is hearsay, the rule excluding its admissibility is subject to numerous exceptions. So there are some exceptions to hearsay, which we will talk about. And I'm not going to go into the history of hearsay. I mean, you can read that in the text. It's straightforward. And I'm not saying it's not important, because it's important for you to understand where we came from so that you know why we are where we are today. But I don't see any need in going over the same history that's right there in your text. It's not terribly involved. So you can read over that section. Alright, so there is, again, the definition of hearsay. Rule 801C of the Federal Rules of Evidence define hearsay as a statement other than one made by the declarant while testifying at the trial or hearing, offered in evidence to prove the truth of the matter asserted. A declarant is the person who makes a statement either in or out of court. So basically it's a statement not made by the person testifying. They're just repeating what they heard, basically, and you cannot do that. That is basically not necessarily admissible. It also says that the declarant's statement must be an assertive statement offered as proof that the subject matter of the statement is true in order to fall within the hearsay rule. An assertive statement is one in which the declarant intends to communicate a thought or belief. If they're trying to give you some information that would help you make up your mind to assert something before the court. There's a difference between just a blanket, what I would call a blanket statement, and an assertive statement. An assertive statement is where they actually have a goal in mind. A blanket statement is they're just simply putting facts out there. And there's a difference. If they're putting facts out there, then it's very possible that's probably going to be admissible. But if they're actually they have a goal in mind, and that goal in mind is to either secure a conviction or to secure an acquittal for whichever witness that they're testifying against, then it's very possible that unless they have personal knowledge of whatever the facts are, then that assertive statement is going to be inadmissible. Okay. Nonverbal communications can also be assertive. It is hearsay if the purpose of the nonverbal act is to communicate and the communication is assertive. Example, a witness testifies that when she asked X where his drug dealer lived, X pointed to the defendant's house. Now, if the witness, had been to the drug dealer's house and she could tell you where the drug dealer's house is, that's one thing. But when she is saying that she was with X and X pointed to the house and told her that's where the drug dealer lived, and then now she's testifying to that, that's hearsay. That is not allowed. She has to have personal knowledge of it. Conduct that is not meant to communicate. If a person is engaging in conduct that is not meant to communicate, this would generally not be treated as hearsay, and there is no attempt to be assertive. And here's an example of that. A police officer showed the victim a group of photographs. When the victim saw the photograph of the defendant, the victim gasped and began to cry. That's just simply, again, stating facts, and there's not necessarily a goal there according to that testimony. Just putting it out there. You can decide what you want to decide from that set of facts. It's not meant to communicate, therefore it's not meant to be assertive before the court. Statements offered to prove the truth of that statement. If an attorney can convince a judge that a statement offered for use in evidence is meant to prove something other than the truth of that statement, the judge may rule that that is admissible for evidence. The hearsay rule forbids only statements offered to prove the truth of the matter asserted. It does not forbid something other than truth of that statement. And what that means, and that's a lot of words there, and it's somewhat confusing. What it means is, if what you say does not go towards securing the conviction of the defendant, then it's probably admissible. But if it does go towards securing the conviction for the offendant, then it probably would not be admissible if it was hearsay evidence. So, if it's just something to give some background or to help somebody understand a situation, but it's not information given to try to prove the guilt of that defendant, then it's probably not going to be considered hearsay at that point, and it would probably be admissible. Removing statements from hearsay classification. The following examples illustrate a few of the numerous other purposes that would take an out-of-court statement out of the hearsay classification. So, such as knowledge, feelings or state of mind, insanity, effect on the hearer, independent, rational, significance, and you can read all of this in your textbook. Basically, the judge would allow information given under those examples only for the allowable purpose. And it means basically it's not going to be for the purpose of proving the guilt of the defendant. It's just going to be in order to make the picture a little more clear, if you will. What is not hearsay? Besides being limited to assertions offered to establish proof, the hearsay rule does not apply to various out-of-court statements that would otherwise literally fall within the definition of hearsay. So, in a nutshell, hearsay is really simple. It's that if a witness is trying to testify to something that somebody else said to them for the purpose of securing the conviction or making that person look bad in the eyes of the jury, then it's probably going to be hearsay. Pretty much anything else that falls outside of that realm is probably not going to be hearsay. Hopefully that makes sense to you guys. Prior statements by a witness. If a witness testifies at a trial and is cross-examined concerning an earlier statement made by a witness, the statement is not hearsay if the statement is inconsistent and was given under oath at a previous trial, hearing, or deposition, or the statement is consistent and is offered to rebut a charge that a witness present testimony is a recent fabrication or stems from an improper motive. So, when we look at prior statements of witness, this is on page 179 in your textbook, and it gives you some really good examples, and you need to read over those examples, try to get straight in your mind about again, this is what is not considered hearsay. One of those things being prior statements by witnesses, as well as admission by a party opponent. And what that means is where the statement sought to be admitted is an out-of-court statement made by the defendant, a party in the trial, or someone acting on his or her behalf. Federal rules of evidence provide that the statement is not hearsay, and there's some examples under that. And also, if there's a co-conspirator, statements by a co-conspirator made during and in furtherance of the conspiracy are also not hearsay. So, if they're telling you the conversation they had with the other defendant in the case that goes to prove the conspiracy and their criminal responsibility in the case, then that's not hearsay. It's just not. So the justification for this rule is that parties in a conspiracy are essentially partners, and an admission by one partner is fairly attributable to the other partner as well. So again, we look at some of these things that are hearsay versus some of the things that are not hearsay are pretty important, and honestly don't make it any more complex than it actually is. What I'm most concerned with in this chapter is that you know what hearsay is, what hearsay is not, and then basically what are those specific things that we already know up to this point would not be considered hearsay. And then this chapter 8, is going to be concerned with the confrontation clause and exceptions to the hearsay rule. And again, I'm not going to talk about everything in this chapter, but the first thing I want to talk about is the confrontation clause. In criminal trials, the admission of out-of-court statements presents not only issues under relevant hearsay rules, but also potential conflict with the Sixth Amendment's confrontation clause. And the confrontation clause entitles a defendant in a criminal case to demand witnesses testify against him in his presence. So basically, the confrontation clause allows for a defendant to require anybody that is providing evidence against him to be there and to testify as to what they know. And again, they cannot testify to stuff they do not have personal knowledge of. So if there is a statement that has been made out of court that we might not consider hearsay, there's a problem with that being admitted at trial because the defendant cannot confront that witness that made an out-of-court statement that some other witness is now testifying to. So you start to see where this starts to get a little more complicated here. So if an out-of-court statement is admitted as evidence against the accused, the person making that statement is a witness who is not confronting the accused. Prior to 1965, the confrontation clause applied only to federal criminal trials, was not extended to state criminal cases, but it has at this point been extended to state cases. And says a state might have an evidentiary rule that permits admissibility of hearsay evidence in criminal cases for reasons unique to their state evidentiary system. In such case, the state's justification for admission of the hearsay must pass the confrontation clause test. Basically, can that defendant be confronted by that witness in court? And if not, then it's probably not going to be admissible. So, what are some of the solutions in regard to the confrontation clause? Well, the following questions will help identify the correct solution about the admissibility of an out-of-court statement. Is the statement hearsay? If it's not hearsay, then that person should be able to testify, right? They should be able to come to court and testify to it. If it is hearsay, is it testimonial? Is it trying to prove or assert the facts of the assertion? And what we're talking about there is it going to prove the defendant's guilt? Is it going to help the jury make a decision? If it's not, then it's probably going to be allowed. But if it is, then again, because there's no confrontation happening, it may not be admissible. So if it is testimonial, the confrontation clause requires the person to be in court and available for cross-examination. If it's not testimonial, the confrontation clause issue, no confrontation clause issue arises. Next question is, does the forfeiture by wrongdoing rule apply? And I want to talk about that for just a second here. Let me find that in your text. Forfeiture by wrongdoing. A rule permitting the admission of hearsay evidence as a penalty against a defendant who wrongfully made the declarant unavailable, often used in murder cases. So, if the witness cannot actually come and testify because they're dead, and the defendant is the one that killed them, then what they can usually do is get admitted into court, whatever that witness said, out of court. And there's no physical way at that point to get that person into court so that they could be cross-examined. So we're going to probably allow whatever they said to come in, especially if the defendant is the one that caused them not to be in court, if that makes sense. The defendant has forfeited the confrontation clause issue in that particular instance by their own wrongdoing, by ending the life of the person who could be there testifying against them, if you will. So, and the last question is, if the statement is not testimonial, does a hearsay exception apply to make it admissible? Is there some other exception that might apply? And in some cases there are, because there are some exceptions there. So you can read these court cases. Crawford is a major one. Be familiar with what the meaning of testimonial is, because that's going to define whether or not the confrontation clause applies. Again, another one, Davis versus Washington, Hammond versus Indiana, major case, Michigan versus Bryant. Here's some examples of non-testimonial hearsay. Courts have concluded that the following hearsay evidence is to be non-testimonial, and that means that it can be admissible in court. It is hearsay, but it's not testimonial in nature, such as breathalyzer calibration records. You're going to have the person that took the breathalyzer exam on a drunk driver there to testify what the result was. But you can have the records of the machine admitted without any problem, without the person who actually did the calibration being there to testify that they did the calibration. It just proves the fact that the machine was reliable. Any statements made to the victim's lawyer, the lawyer can typically get up there and say, well, I spoke with so-and-so and here's what they said. Drug slang, meaning a tip to a 911 operator, or even a certificate of nationality. We don't actually have to have all of those people present to be cross-examined. We will allow that evidence to be considered non-testimonial and therefore be admitted, because it makes the picture clearer for the jury, but it doesn't really prove guilt. If it were to be going toward proving guilt, then it would be testimonial in nature. If it's not going to prove guilt, it's not testimonial. Another case here, Melendez-Diaz versus Massachusetts, Wyoming versus New Mexico. You can read those cases. It has to do with DNA evidence, expert testimony, forensic results. Here's some more of that forfeiture by wrongdoing. You can read some more of that. Giles versus California. Autopsy reports. Are they testimonial hearsay? Courts differ on the admissibility of an autopsy report if the medical examiner who performed the autopsy is unavailable to testify at a trial. This is not uncommon in cold case investigations. So it just kind of depends almost upon the case and upon the state law, on their rules of admissibility. But I think you could understand that if a murder happened 40 years ago and the person that did the autopsy is probably deceased at this point, then the person that did the autopsy is not going to be there to be cross-examined. So what you're going to have is an autopsy report and nobody to testify to it. And in that case, you may even have to get a current medical examiner to testify as to what's in a previous autopsy report for an autopsy they didn't even perform, which again brings up a lot more issues and problems. But that may be the only way you could get that in. Or if the autopsy report is not considered testimonial, it's just being there to clear up to make the picture clearer, if you will, then hearsay rule wouldn't apply anyway. Testimonial rule wouldn't apply, and it'd be admissible. But if it is testimonial in nature, it does raise some issues. Other courts rely on the presence of other purposes for autopsy reports. There are some firmly rooted exceptions to hearsay because the Confrontation Clause has no application to statements that are not testimonial. In such cases, whether or not the evidence comes in is purely a matter of state or federal rules of evidence law. So what are some exceptions to hearsay? Exceptions to the hearsay rule for admissibility of non-testimonial hearsay should be permitted only when reliability can be assumed. Hearsay is not admissible as evidence unless there is a showing of substantial reliability for the statement. You've got to show some reliability for what's going to be said before it would be admitted, even if it was an exception to the hearsay rule. One of these exceptions is the excited utterance exception, and this is an interesting one. This is a statement relating to a startling event or condition made while the declarant was under the stress or excitement caused by the event. So basically, if let's say you were driving in your car and you were intoxicated and you ran over a child and killed a child, and the police officer on the scene gets there and you are just almost beside yourself. You've realized what you've done, and before you realize what you said, you tell the police officer, oh my gosh, I was drunk, I shouldn't have been driving, and I couldn't stop. Didn't see the kid and I couldn't stop. And let's say at that point that you become a deaf mute. And you cannot be cross-examined for your statement. The police officer could probably testify as to what you said under this exception because it was an excited utterance. He wasn't questioning you. You just had diarrhea of the mouth, if you will, and you opened up and told him things that incriminated you, and now he is testifying to that. He may not have known that you were even the driver when he got there. You're just somebody that walked up to him and said, it was me, I did it, I was drunk, I shouldn't have been driving, I didn't see him, I couldn't stop. In that case, he can testify as to what you said. It says the reason for the exception is that if such statements are in response to the startling event, the trustworthiness of such statements comes from the fact that the victim or witness had no time to reflect and possibly fabricate the statement. It's just something that just kind of rolled out. It wasn't expected, nor was it commanded. It was just an excited utterance. Examples of excited utterances: statements made during or immediately after a shooting, stabbing, or robbery. Statements of rape victims after the crime. Recorded 911 calls and other calls in which the caller was speaking under stress. I'm not going to really talk about the existing mental, emotional, or physical condition exception. You can read about that one. That one's pretty interesting too. Statements for the purpose of medical diagnosis or treatment. You can read about that one. That's an exception. Regularly kept records. If records are being regularly kept for something, then those records could be admitted without actually being able to cross-examine somebody. They would just be admitted as part of the case. However, they may be able to be attacked by the opposing party, and maybe be able to kept out under some other reason, but they would generally be found to be admissible if it's regular records kept. It's not something that was kept for that particular instance, but as a general course of record keeping, and now you're just trying to use that to help make the picture clearer. This is one of my favorite ones. I want to talk about this one for just a minute, called a dying declaration. If you get into law enforcement or investigations or emergency medical services, you will probably see this one happen. The dying declaration applies to statements made under belief of impending death. The reason for the exception is that when one is facing death, every motive to falsehood is silenced, and the mind is induced by the most powerful considerations to speak the truth. And basically what it says is that, let's say you are the first officer on a scene, and you have a shot, wounded, and potentially dying victim. And the victim tells you that Jim Stewart shot me. And then the victim dies. That police officer could then testify to the fact that the victim told him that Jim Stewart shot him. And the reason why is because two tests have been passed. And one is the victim must believe they're going to die, and number two, they must die. If the victim believes they're going to die and they pull through, then the victim is going to have to testify on their own behalf. The police officer cannot testify to what the victim told them if the victim is alive. But if the victim believes they're going to die and they do actually die, anything they tell the police or emergency medical or even a potential witness, on any other witness on the scene, is probably going to be admissible under the dying declaration exception. There's a few other exceptions here. Statement against penal interest, you can read over that. The fresh complaint, the outcry rule, you can read over that as well. Modern hearsay exceptions in child sex abuse cases, make sure you read over that one. That one's pretty interesting. That's one you're also probably going to see fairly regularly as well. So again, when you see a legal rule in place, there's probably going to be multiple exceptions to that rule. And the purpose of this integrity video was to go over some of the most common exceptions to hearsay, and then have you understand the confrontation clause, and then what hearsay is and what hearsay is not. So hopefully this clears up any questions you may have. Make sure you read and reread these chapters. You are going to be having a midterm exam coming up next week, probably over the first 8 or 9 chapters. So it's probably going to be somewhere in the neighborhood of about 50 questions, and it's going to be true, false, or multiple choice. And I expect academic honesty on the exam, and do the best you can. If you have any questions, reach out to me. I'm here for you. Send me an email, send me a text through course messages or whatnot. Have a good week, and I'll see you next week. Bye-bye.